Good afternoon, everyone. Welcome, welcome, welcome. My name is Kenita Williams. Welcome to the American Bar Association's Construction Law Forum's Toolbox Talk series today, where we'll be discussing motions practice in construction arbitration. Is it worth it? We have our guests, Jen Millender, Adrian Bastianelli, and Brian Cashmere. Jen, if you want to take it from here and introduce our guests. We're going to have a fruitful discussion, and please remember to put your questions in the chat.
I will. Good morning or good afternoon, everybody, depending on where you are. As she mentioned, the title of our discussion today is Motion Practice and Arbitration. Is it truly worth it? We have with us Brian Cashmere. He's a partner in the construction government contracting practice at Williams Mullen. For more than 25 years, Brian's provided counsel for and dispute resolution support to clients in the construction industry. He's developed a wide range of experience in all aspects of the industry, working with contractors, subcontractors, suppliers, sureties, and owners. His construction experience runs the gamut of having worked in all phases from pre-bid and development through closeout, and includes dispute resolution experience in courts throughout the U.S. and arbitration both domestically and internationally. His experience includes the preparation, submission, and argument of multiple pre-hearing motions, including multiple motions for summary disposition under AAA rules. So obviously Brian's position here today is to give us information from the advocate perspective. And we also are lucky enough to have with us Adrian Bastianelli, who is of counsel at Peckar and Abramson's Washington, D.C. office. He is the past chair of the forum and a Cornerstone Award recipient. He's a fellow in the American College of Construction Lawyers, and he's recently transitioned his practice from litigation to primarily neutral work involving serving as an arbitrator, a mediator, and a DRB member. So as we mentioned at the top, we're going to discuss motions, and we thought we would start with the traditional true dispositive motion. And so, Brian, as the advocate, what is your perspective on filing dispositive motion?
So, well, thank you, Jen, for that introduction. So, yeah, from an advocate standpoint, I'll tell you, I have a little bit of a mixed view on them, but generally bullish. But let me start with full disclosure on those motions. With respect to dispositive motions in arbitration, I have a sound, consistent record of 0 and 5. So I have submitted 5 summary judgment motions before AAA panels, and I have been denied all of them. So that said, I don't regret any of them, and I'll go through a couple of points. And the first one is that to an understanding for everyone who hasn't done it before, the rules allow for it and the law allows for it. Sometimes you have to educate the other side and the arbitrator on that, but there is case law consistent in most jurisdictions. I think California is an anomaly where I think that there's case law against summary judgment, but for the right issue, it works, okay? And you will find case law out there. Most recently, I've done one in New York in which there's strong case law where on a post-arbitration petition, the courts in New York have held that arbitrators have the authority for dispositive motions. The question then, though, really is, what are the considerations? And the first one for me is the legal consideration. It has to be the right issue. It has to be clean, concise, discreet. In Virginia, we have this concept known as a plea in bar, where it's a single issue presented to the trier of fact and law. And that's what you need to have. You need to have a statute of limitations, a notice issue, something like that would favor an arbitration summary judgment. One that gets into causation, where you might think about it in court because you've had enough discovery and you have deposition testimony and you have a 30B6 transcript to help you. I would probably stay away from that. But statute of limitations, limitations of liability, damages limits, I would be bullish on. And as well on that is the concept of partial summary judgment. I'm a big believer in that. And in that 0 and 5, 2 of them were for partial summary judgment. in which while I was denied the motion, I was given favorable orders from the arbitrator that limited the case. So a contract interpretation issue, and I believe construction law is well suited to this, right? There is a lot of discrete issues and contract defenses that can be presented. So that's on the legal side, but there's practical components of this too. And Adrian and I talked before this, and we've known each other for some time, and he pointed out to be some of the cons, but the pros are you have the potential to win. While I am 0-5, I did do a survey of others in my firm, and while none of the advocates have, the two senior folks in my group, to include Keith Kapp and Bob Cox, have served as arbitrators, and both said they have granted summary judgment. So you do have a possibility of winning. You have the possibility of narrowing an issue. And worst case from my standpoint is you get the opportunity to educate the arbitrator and the adversary as to strengthen your case. And by the way, if you don't have a strong summary judgment motion, don't go down the road in arbitration. It's a steep enough hill as it is. If you don't really have a good one, don't go after the low hanging, or go after just the low hanging stuff. Don't go after a reach. But educating the arbitrator, one recent colleague of mine, I was discussing this, and don't know if I can name drop, but I'll give him credit because it was his idea. In talking about this with Steve Seeger at Kozar O'Connor, just Jen, a couple weeks ago with you, he pointed out, well, a summary judgment motion arbitration is akin to a pre-hearing brief. Okay, you might not get very far, but you get a chance to get that out there. So that's another positive aspect of it. The drawback being maybe there's a better way of doing that. Maybe just wait for the pre-hearing brief. The cons quickly are there's a low likelihood of success. And I don't know, Adrian, your experience back in the day when you were, the advocate, it's even hard in court to get summary judgment, right? It's harder in arbitration, but it's even hard in court, where courts have full discovery and summary judgment after discovery and depositions. So it's low likelihood of success. But then it really comes down to the practical side of time and dollars. Do you have the time and the money in your litigation estimate and budget to do it? And that is an important component of it. So those are sort of the cons of it as well.
Let me jump in here, Brian, because I think when I listen and look at this, you probably always win your cases, win your motions. But what happens if you lose your motion? And I think too often parties don't actually look at that side. It's a question of they're thinking about winning the motion. And what I see all too often from the arbitrator's perspective is people who have slapped their motions together and say, let's just try this. And if we win it, great. If we lose it, so be it. We'll move on. But what they can end up with is a decision against them that sticks with them the rest of the hearing. So that, I think, is another con side that you want to think about, other than just simply that you're going to win the case.
True, and that you're right. So if particularly, I did say go for the clean shots where you think you have a strong argument. Losing is not always the worst thing, because again, it narrows the issue. If I lose on a motion for statute of limitations, I've at least narrowed the scope of the hearing. I've now preserved it for any challenge later. But you're right. If you're going to do it right. But that by way is one of my rules overall. I have a couple of my associates in the gallery. Just remember that if you're going to do it right. There's no halfway. But you're right. You could lose. That has to be in the calculus. Is if you lose it. One of the reasons, again, the pros is to try to advance settlement, right? Because let's keep in mind, 80% of these are going to settle before they go to arbitration. Is it going to help you or hurt you in settlement? And sometimes it's not good to do it, because if you lose, you've hurt yourself in settlement, right? The threat of it going to hearing is sometimes better. So that's another consideration as you're going through that idea. So I've talked enough, Adrian. Maybe what are some of your thoughts from the arbitrator's perspective on this?
Okay, let me even just touch on a couple of points you said, and I would reemphasize, and you'll hear it reemphasized a couple of times. You really want to do strong cases and you really want to do it right, because like I say, I've seen an awful lot of motions where it appears that the parties counsel hasn't spent the time that they should, and that can come back truly to bite them. The other side is it ought to be a motion the arbitrator can decide, because otherwise you're going to antagonize the arbitrator. He's going to think he's going to draw his first impression of you as somebody who files these frivolous motions that can't be decided. One of the other things, as far as teaching the arbitrator your case by using the motions, I would say if it's a real motion, then the arbitrator is going to spend the amount of time that they need to decide it. If it's a frivolous motion, just simply because they think they're going to teach the arbitrator something, what you may find, or what you'll find, maybe I should just talk about myself, is that I probably am not going to spend a lot of time reading cases and reading what you submitted once I see that the motion's going to go away. So you're not going to teach me too much other than that you're filing a frivolous motion. So make sure you have a real one. Now, as far as chances of winning, from the arbitrator's perspective, I've probably heard hundreds of dispositive motions of the last 40 plus years serving as an arbitrator. And of those hundreds of motions, I can count with my fingers on my two hands how many I've granted. So
I got a chance. I got a chance.
You got a small chance. The key to it, well, the question, I guess, is why in arbitrations don't arbitrators grant more dispositive motions? And in my mind, the primary reason is that almost every legal issue has a fact-dependent part of it. It's very, very hard to find issues that are purely without a fact issue. And once you get fact issues in there, the party's going to be able to raise it. In fact, I always say any reasonable, competent lawyer almost always can find find a factual issue that prevents the arbitrator from deciding a dispositive motion. And I guess when I look at it from 40 years of hearing cases, what I do know is that when I look back at the end of a case and say, now that I know all of the facts, does the dispositive motion look the same as the issue I'm deciding now that I know the facts? And I think just my gut feeling is that they look completely different almost always. So yeah, if it's not a clean issue, I'm going to feel much better having heard the whole case rather than trying to get rid of it up front. The second reason I see that dispositive motions are not granted by arbitrators, or that an awful lot of them that are raised don't shorten the hearing or save costs. And if they don't shorten the hearing or save costs, I think you're going to find most arbitrators wanting to say, if I've got to hear this whole thing, I'll decide everything at the end of the day when I have the better knowledge of all the issues and how they fit together. And then the third one that I would put out there is that, and this is I don't believe in it, but some arbitrators are concerned that if by excluding evidence, they can give a party a basis for vacating the award. And a lot of them believe that I've read the decision say that an arbitration, a party is entitled to a full evidentiary hearing. And by dismissing it, they're taking a chance that they're going to be reversed. But as Brian said early on, the AAA rules and all the case law says that the arbitrators can do it. And if it's the right case, I'm a big believer that the arbitrators should be stepping to the plate in doing it. So for the litigators on the call, the question I think is, how do you get the arbitrator to grant your dispositive motion? And in my view, I would go back to, I guess I go back to the fact that I believe that good lawyers and good arbitrators recognize that if a case really turns on a legal issue and not factual issue, they owe it to their clients and the arbitration process, as far as I'm concerned, to have the issue determined through dispositive motions to save the time and money for everybody. However, the problem is that it's typical to want to put it off if you think you're going to lose, and the way to put it off is to raise factual issues. To accomplish, to get an arbitrator to decide a dispositive motion, I think takes cooperation of counsel and the arbitrator. You need to get together with your opposing counsel and figure out a way to fix the facts so that the arbitrator can decide it. One way stipulations, but I know, having spent 40 years, 50 years fighting cases, getting somebody to stipulate that the wall's white is almost impossible. So you may not be able to get stipulations. But one of the things I've seen done, and I'm a big proponent of, is to have a short half-day hearing or one-day hearing on a single issue, and have the arbitrator find the facts necessary to decide the motion. But that only works if the parties are willing to set the process up.
Yeah,
go ahead.
Yeah, and Adrian, a similar component to that, and without disclosing client confidences, I'll throw this out. Adrian was actually a mediator for me several years ago in a case in which both sides had very different contract interpretations. Adrian wasn't able to successfully mediate it, but he threw out a suggestion at the end of the mediation that said, this is right for both of you to do cross motions for summary judgment to get it resolved. 6 months later, that's where we were. It took more time and effort, but we did cross motions for summary judgment there in federal court, not an arbitrator, but before a judge. And exactly that suggestion is what worked it out. Both parties agreed while we were at mediation with you that we had different interpretations of the contract. We did a cross motions for summary judgment, and that's how it got resolved. So similar to that idea, Adrian, if you're doing a service to your client, rather than prolong it, cost effectively agree to that process.
Yeah, to me, if you're a good lawyer, what you want to do is, and you know the legal issue is dictating the outcome of this case, you really do need to work with your co-counsel to find a way to do it. The example I was going to give was a case in which there were a lot of legal issues, and they took them one by one and defined the issue, stipulated where they could, and came in and did half-day or day hearings and got the decisions to the legal issues, which allowed them then to go ahead and settle the case. To me, the bottom line is, if a case turns on a legal issue and you want to have it decided by summary judgment, both parties can come together and come up with a process that I think will get that done. And that is the beauty of arbitration, is there's a lot of flexibility to design a process that can save time and money.
Sort of speaking to that, if I could,
Yeah.
because we're talking about, you know, the savings of time and sort of narrowing scopes of things. What would be a timeline? And I'm going to take a step back. Assuming that in your initial schedule, there was no plan for these dispositive motions, they're being raised after the fact. What would a timeline be? Because if you've got a schedule in place already, how are you going to fit this in so that you can determine whether it's got some teeth to it and really could, you know, change the scope of the arbitration? What would be a timeline for when they should be filed?
From an
I
advocate.
guess I'll go to you, Brian, first, and then
Yeah.
Adrian.
From an advocate standpoint, I approach the case management and I ask for that date, even if I'm not sure it exists or not. Okay. Similar to in court, you have a dispositive motion cutoff. In court, it's tied to the end of discovery. More and more, you're getting some limited discovery in arbitration. So I tie it there. But again, it's open. It's when do you think it's the right time?
And I think most of the proposed scheduling orders that are given to me will tie to the end of the discovery somewhat. But I think you would, if you've got a true issue that doesn't have any facts, or the parties are able to agree on the facts that are undisputed, I would bring it before you spend all the money on the discovery if you can. You still set the date that they have to be filed after the close of discovery. But I think that again goes back, that seems to assume that the facts are going to drive the decision.
And earlier is better. And right, because that's the purpose of this, is to narrow things and be more cost effective, to avoid the discovery, avoid the actual hearing time. So earlier is better. But one of the things, and in that 0 and 5 record, many of them are, there's facts in dispute, you know, similar to what Adrian said. Yeah, it's a notice issue, but the question is, was notice given, right? Notice issue is a question of law. Was it given is a question of fact. You're going to lose on that. But part of that timing is what a lot of times people say is, I need discovery. As soon as an opponent's summary judgment says that, you're in trouble. So as an advocate for summary judgment. So you likely go early, but know if that's going to be the response, you're going to have to wait.
Yes. Let me give you a quick couple of hints. If you can't agree with the other counsel and you want to file a motion, what should you put into it? How do you attack it? And I think the first thing is you need to emphasize to the arbitrator that there will be a savings of time and money, because if there isn't going to be a savings of time and money by granting it, it's over, I think, most of the time. And you should be laying, I think, a guilt trip on the arbitrator to say, look, are you going to put the clients through all of this cost when and all of this time, when arbitration should be quick, inexpensive, when it can be disposed of right now, and make him or her feel guilty of not doing it. The second is when you're going to want affidavits or backup for the facts you're alleging. But one of the things I see all too often is that the parties come in and they put all the facts of the case into it. They want to educate the arbitrator that they have a wonderful case and they have all these equities on their side. If you do that, you're very likely to lose it, because there are going to be a lot of contested facts. So if you're going to if you really want a motion for dispositive motion decided, you want to have a very limited group of truly uncontested uncontested facts. If you can't get there, it's unlikely that you're going to prevail on it.
Adrian, what are your thoughts? I think that first point you touched on a little bit, and I see in the comments section that Amy Eichmann pointed this out, which I'm seeing more and more of, and I think the rules for the AAA support it, and that is arbitrators requiring a pre-motion letter even to get to the threshold of allowing you to do that. And I'm seeing that more and more. What do I need to do in that pre-motion letter to convince you to let me do this?
Yeah. And Rule 34 of AAA's rules do require you to seek the right to file the motion. You can't just file the motion. And I think most arbitrators are going there because they don't want somebody with a lot of money running up the bill for somebody, particularly running up the bills for somebody who may not have it on a motion that isn't going to work. But to me, the focus, most of the people who file those letters are trying to convince the arbitrator they're right. They try to write the motion in the letter. I think the key is what you're trying to do. It's not about winning. It's about convincing the arbitrator this is the unusual submission situation where you should allow the parties to brief the case. This is different. There is a big savings of cost and money. There are not disputed facts out there, and the law is going to decide this whole issue. So let me do it. It's not normal, and it's not about winning the case in that letter. At least I don't think it is.
Good. Well, thank you. That's my next week's project. I appreciate the input.
As we were saying, the rules do sort of say you have to seek permission. How, 3-5 pages, do you give guidance as the arbitrators to what you want to see in that letter, that request letter, and the length that the request letter be, so that they don't, as you say, try and put the motion in the letter itself?
I think 2 pages is fine. I go to sleep pretty quickly, so trying to write a long letter laying out your whole case isn't the right thing to do. You may take 1 paragraph to sell your equities in your case, but then you really should limit it to 2 or 3 pages at most. You're trying to get the arbitrator to just say, yeah, I'll let you file the rest of it. Yeah, Brian.
As an advocate, the one thing I'll say to those of you out there, and I apologize to the AAA and Jen, but one of the strategies I use to get around that is at the case management hearing with the or the initial scheduling meeting with the arbitrators, convince them then, okay, that look, there's this issue. Let's all agree to have this done, and here's the date on the specific issue. And sometimes, in fact, I've had good success. 50% of the time, you'll get a date for that specific issue at that time if you know it's coming up. So I've also 50% of the time been told, put it in a letter.
We've got just a couple of minutes left if anyone has any other questions, so that I'm not the only one asking questions, because I'm happy to chat, but this is all for an interactive type of scenario.
Any more questions, anyone?
And you can unmute yourself and ask now if you like, because we've got literally about 2 minutes left. You guys,
no
did
questions for
well
Adrian. I understand not asking me questions, but if you have 2 minutes, Adrian Bastianelli's time, and you're not taking advantage of it.
We answered all the questions, Brian. We were thorough.
Yeah, but we had even had discussion about some of the other potential motions that we were going to raise, but the dispositive is the one that is always the most sensitive. So we really didn't get a chance to go into the others. And I don't want to launch the topic now when we've got less than a minute left, but
Well,
Yeah.
and let
There
me,
are other motions.
there are. Let me just take one shot at it. Don't file a motion to dismiss an arbitration. Just don't do it. If you have a problem, ask someone to update their statement of claim or answer. Motions to dismiss, I've defended against several. Given the pleading standards in arbitration, you're not getting a motion to dismiss granted for failure to state a claim. That's a waste of resources in my view. That's my one soapbox moment.
Okay, well, that
100% true.
Okay, well, that brings us to our end. It's now 12:30. I did put in the chat the link for our next Toolbox Talk series, which will be on October 26th. So we have pretty much the summer off. But that'll be on scheduling methodologies. So if anyone's interested in discussing scheduling methodologies, please join us. And thank you guys for being such wonderful presenters. That was very informative.
Yes, definitely, gentlemen. Thank you very much for your time. Thank you, everybody, for
Thanks,
tuning
everybody.
in.
Thank you,
Hopefully
Jen.
It's beneficial.
And hopefully
All
I'll
right,
see some of
everyone,
you at the
enjoy your
DC
summer.
meeting.